All right, I am informed that we are live and the YouTube is working, so I'm going to go ahead and get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference in Phase 1B on the applications of North Kern Water Storage District and City of Shafter, that's application 31673, City of Bakersfield, application 31674, Buena Vista Water Storage District, application 31675, Kern Water Bank Authority, application 31676, Kern County Water Agency, application 31677, and Rosedale Rio Bravo Water Storage District, application 31819, all for permits to appropriate water from the Kern River system. This pre-hearing conference is being held in accordance with the Notice of Pre-Hearing Conference and Notice of Public Hearing dated January 12, 2022, and the notice vacating Phase 1B hearing dates dated January 25th, 2022. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time during this proceeding you are experiencing technical difficulties and are having trouble communicating with me or my staff, please send us an email to the AHO at adminhrgoffice@waterboards.ca.gov, and my team is monitoring that email inbox and they can let me know that you're having trouble. Assisting me today are several staff of the Administrative Hearings Office. We have Amy Blunk, Skylar Anderson, and Kyle Wooldridge. At this time, I would like to move to appearances. To do that, I'm going to identify each of the entities that has filed an NOI for Phase 1B of this hearing. And as I do, if you would please, if you're representing that entity, please unmute your microphone and state your name. We will start with the City of Bakersfield.
Good morning, Ms. Kunze. Colin Pierce of Dwayne Morris appearing for applicant City of Bakersfield, and also appearing with me is my partner, Joleanne Ainsley.
Thank you. Good morning, Mr. Pierce and Ms. Ainsley. City of Shafter.
Good morning, Ms. Kunze. Patrick Scahan with Best and Krieger for the City of Shafter.
Thank you, Mr. Scahan. North Kern Water Storage District.
Good morning, Hearing Officer Kunze. This is Scott Cuny from Young Wooldridge appearing on behalf of North Kern Water Storage District.
Good morning, Mr. Cuny. Buena Vista Water Storage District.
Good morning, Ryan Bizzaro of Barkowitz, Chronic, and Shanahan for Buena Vista Water Storage District. Isaac St. Lawrence is also here with me today representing the district.
Thank you. Good morning, Mr. Bizzaro and Mr. St. Lawrence. Rosedale Rio Bravo Water Storage District.
Good morning, Jennifer Spalletta Law for Rosedale Rio Bravo.
Good morning, Ms. Spalletta. Kern Delta Water District.
Good morning, Ms. Kenzie. Robert Donlan for Kern Delta. Joined today by Craig Carnes in my office and Kern Delta's General Counsel, Richard Iger.
Thank you. Good morning, Mr. Donlan, Mr. Carnes, and Mr. Iger. Kern County Water Agency.
Good morning, Ms. Kinsey. Nick Jacobs with Somax, Simmons & Dunn, representing the Kern County Water Agency. And I am informed that there was an issue with the YouTube, but it just started running. Okay.
Good. Okay. Thank you. Good morning, Mr. Jacobs, and thank you to all of you. Please let us know if something is going on with the YouTube because I can't see it. My team is watching it, but I can't see it. Tulare Lake Basin Water Storage District.
Good morning, Ms. Kenzie. This is Peter Keel.
Good morning, Mr. Keel. Kern Water Bank Authority.
Good morning, Ms. Kinsey. Kevin O'Brien of Downey Brand for Kern Water Bank Authority.
Good morning, Mr. O'Brien. The public interest groups, that is Bring Back the Kern, Kern River Parkway Foundation, Kern Audubon Society, Kern Cahuilla Sierra Club, Panorama Vista Preserve, and Center for Biological Diversity.
Good morning, Ms. Kinsey. This is Adam Keats. I'm appearing on behalf of those parties.
Good morning, Mr. Keats. And you may well know this, but I don't have video of you, which is fine, but just so you know. We can't.
Yes, I know. I'm in a bad internet place. I might
Sure.
be moving to phone pretty soon. I'm sorry.
That is fine. Thank you. California Department of Fish and Wildlife.
Good morning, Ms. Kunze. This is Nancy Murray appearing for California Department of Fish and Wildlife.
Thank you. Good morning, Ms. Murray. Is there anyone else who intends to participate today who has not already had a chance to identify themselves? Wonderful, then we'll move on. I will start with acknowledging the pre-hearing conference statements that I received. I received pre-hearing conference statements from Kern Water Bank Authority, Kern County Water Agency, City of Bakersfield, Buena Vista Water Storage District, North Kern Water Storage District, and California Department of Fish and Wildlife. I then also received Kern Water Bank Authority's objection to Buena Vista Water Storage District's pre-hearing conference statement and Buena Vista Water Storage District's response to those objections. Are there any statements that I missed that you believe have been filed and that I did not identify? I want to make sure that we have those in our files and that I am aware of them. Good, we're on a roll. So to preface this pre-hearing conference, I think this will take a little while. So, which is good. We have a lot to work through. I have read all of your pre-hearing conference statements. I read them carefully, but there's a lot there. So don't be shy about reminding me what is in them. I just hopefully can keep track of who said what, but to some extent you may need to remind me if this was your client who took a particular position or not. So I have read them, I've read them carefully, but there is a lot to work through. So please bear with me. In terms of an agenda for this morning, this is what I perceive, and it's very long, but so bear with me. I think first we should tackle some of the questions raised about the scope of the hearing. I think those issues come first, and we should talk about those because that may affect how we set the hearing and the timing of the hearing. Next, I will turn to the hearing dates and associated deadlines. I will do a spoiler alert, and Mr. Pierce, I can't imagine going forward without you. So we will be revising those hearing dates, and thank you for letting me know about your schedule. Just so you know, so all of you can start thinking about appropriate hearing dates, because I know some of you have teams working in the background. I believe, Mr. Pierce, you indicated the week of April 4th involves conflicts for you, which includes the scheduled dates that we had on calendar for April 5th and 6th. I will let all of you know now that I have a planned vacation for the following week of April 11th. And then the week after that, which is the week of April 18th, we currently on our calendar have a tentatively scheduled hearing in another matter on the 19th through the 22nd. And the way our office works right now is we can only hold one hearing at a time. We only have one Nicole Mullen. So that conflict means we wouldn't be able to schedule during those dates. So I just wanted to alert you all now so you can start thinking about the dates, and we can work together on that when we get to that in the agenda. So I believe I got as far as talking about hearing dates, case in chief and rebuttal deadlines for evidence. We can also talk about, I think, an order of presentation to the extent that it may matter. I don't know that we need to hammer it out entirely, but we can talk about that, as well as deadlines for evidentiary motions, a deadline for pre-hearing briefs, and any other related deadlines that you think we should talk about at this point. After that, I think we might touch on the evidentiary record, whether or not I raised for this pre-hearing conference, whether or not the record for phase 1A should be included in phase 1B. And then there may be some related issues about the evidentiary record. Number 7 on my list is to talk briefly about witnesses. I glanced through your NOIs, and so I noticed some I don't want to call them issues, but some things I'd just like to chat about briefly. I think it'd be appropriate today, and we can talk about it again as we get closer to the hearing. And then there are some other miscellaneous procedural items. I think questions about hand delivery of documents, margins on pleading paper, similar things, and we can work through those. And then there may be some other items that I missed that were identified in some of your pre-hearing conference statements. So I will pause at that point to see if there are any other items that you may have raised in your pre-hearing conference statements, or if there are any additional items that may have come up as we move through this proceeding today and that we need to talk about. So that was on my agenda that somehow came out to 10 items. So we have quite a few to work through, and I appreciate your patience. So I'd like to start with the scope of the hearing. I think there are roughly 3 categories of issues about the scope. I think maybe we should talk about the issues related to that Buena Vista raised in your pre-hearing conference statement, and then Kern Water Bank Authority objected to the way in which that was raised, but these issues related to the scope of phase 1B. There is also an issue raised about the water availability analysis methodology. I think we can talk about that next. And then finally, public trust issues raised by the Department of Fish and Wildlife. So those are the 3. I think we should proceed in that order. And they seem somewhat distinct to me. But maybe what I will do is I'm first going to turn to Buena Vista. And if you would please just summarize for all of our benefit. I know you talked about it in your pre-hearing conference statement, but if you might summarize for our benefit briefly, without getting into the, I realize you included citations and you had a lot of substance there, but I would like to hear your brief arguments and concerns about the scope of phase 1B. And then I will hear from Kern Water Bank, and then anyone else who would like to comment on the issues, and we will go from there.
Thank you very much, Hearing Officer Kinsey, Ryan Becerra for Buena Vista Water Storage District. Yeah, our perspective, I think, is pretty simple. It is that in 2010, the Water Board lifted the fully appropriated stream declaration for the Kern River for 2 very well-defined reasons. One was the Kern Delta forfeiture water. The second was because water had flowed through the Kern River intertie into the California aqueduct on several occasions. We have a problem with mutual understanding as to the scope of the hearing and how to address those changed circumstances within the scope of the hearing. But frankly, we think it's quite simple. In 1964, the State Water Rights Board denied multiple applications, including one by Buena Vista, for any additional water above the pre-14 rights that exist in the river. The board found that the pre-14 rights fully appropriate the river. And the hearing record is quite clear as from 1964 as to what the volumes of use were that the State Water Rights Board considered. We believe those maximum numbers listed in that record should be used as an analytical baseline from which to measure whether there's any later actions indicate there might be unappropriated water. We believe this hearing should not be about revisiting the entire history of the Kern River because the Water Rights Board did that already. Moreover, in 1989, when the State Water Resources Control Board adopted the first statewide fully appropriated streams list, they revisited that record and determined that, yes, the river was fully appropriated based on that record, and specifically called out the engineering analysis, excerpts of which we attached to our status conference statement. Again, I believe in the 90s, the Water Board again relied on that information in denying applications. And then in 2010, the Water Board relied on these 2 changed circumstances as saying that there might be unappropriated water. So our strong perspective is this hearing should be limited to the scope, building off of the 1964 record, the volumes of use the Water Rights Board relied on, and that we should not be going backwards beyond 1964 to revisit the entire pre-1914 water rights structure on the river. So that's our basic perspective. We obviously have concerns that Kern Water Bank Authority intends a different hearing scope. We don't know about other parties, but we believe that's a good way to build from an analytical baseline for determining now whether the 2 changed circumstances actually do make any unappropriated water available. Thank you.
Thank you, Mr. Becerra. I'll turn to you, Mr. O'Brien, if you care to respond. And you are on mute currently.
Thank you.
Sure.
I guess the first thing I'll say is I think the hearing notice does a good job of identifying the hearing issues, including the 6 sub-issues that are identified in that notice. I think what you're hearing from Mr. Becerra is an effort to significantly limit the scope of this hearing beyond the scope identified in the hearing notice. And as we said in our objection, they're really making merits arguments here. This goes beyond merely procedural issues. And if we're going to get into a lengthy merits discussion, I think there should be an opportunity for all parties to brief those issues, not just Buena Vista. But setting that issue aside, we think the 2010 order from the board was quite clear, and I disagree respectfully with Mr. Becerra. It did not say that there might be water available for appropriation. It quite clearly said that there is water available for appropriation on the Kern River, and that was based on extensive technical testimony, primarily from a witness from MBK Engineers, who was a joint witness, and the board, and later the Kern County Superior Court, and after that, the Court of Appeal sustained the board's finding that there is water available for appropriation beyond existing rights. The board's order is quite clear that there's water available for appropriation beyond existing rights. So this idea that we're going to, in Mr. Becerra's words, not revisit the scope of pre-1914 rights for purposes of this hearing, I think would very significantly limit this hearing, first of all, and secondly, limit it in an unfair way and in a way that I think is inconsistent with the board's prior order as sustained by the courts. So this is a very significant issue, and it's a very significant attempt by Buena Vista to really restrict the scope of this hearing. They obviously want to focus on what the board did in 1964. And this is probably a theme you're going to get tired of hearing me say, but I'm going to say it anyway. What the board did in 2010 is the most recent and most relevant determination. And the board, following an evidentiary hearing, very clearly found that there is water available for appropriation over and above existing rights on the Kern River. That, as far as we're concerned, that issue has been determined. It's res judicata, and that's the starting point for this hearing, which is really aimed at quantifying that amount of water that's available for appropriation. And I think your hearing notice does a good job of honing in on that issue, because I think that's really what we're here for in this phase 1B. Thank you.
Thank you, Mr. O'Brien. Is there anyone else who would like to comment on this issue, this portion of the scope? Mr. Jacobs.
Yeah, I would.
Thank you.
Oh, and Mr. Cooney, I have you on the list. So after Mr. Jacobs, thank you.
Thank you, Ms. Kinsey. So I think that, Mr. O'Brien's statements highlight the issue that they want a much broader scope of the hearing. And I think that is not what is in the 2010 orders from the board. Those orders found that there was water available for appropriation when the intertie ran. And that is a much different scope of a hearing than what he is describing. And I think that Buena Vista is right to attempt to get a better understanding of what is at issue here, because I think that you're going to get very different presentations and an apples to orange comparison, if you will. I also, and I guess we can talk about this next, but I do think it is related. I really think that the state, we need some feedback from the board on what it intends to do with the water availability analysis that it asked us to do. Now, I think that that may be additive to looking at intertie flows and trying to figure out whether or not one or more of these applications might apply when the intertie is actually running. But this cannot be an inquiry into pre-14 rights that have already been reviewed by the board extensively, going back 60 plus years.
Thank you, Mr. Jacobs. Mr. Cooney.
Yes, hearing officer Kunze, I want to pick up with the comment, and I agree with the statement from Mr. O'Brien that the 2010 order is a divining point in terms of the board's history of considering the availability of Kern River water supply. And what it made clear in the 2010 order is that it said the declaration as adopted by the state board in orders 8925 and Water Right Order 9197 and Water Right Order 9808 is amended to allow for processing. So the point of it being is that all of those prior determinations were not revised in any respect, but rather the issue was whether or not and to what extent there was unappropriated water, either one, because of the forfeiture decision, the 1A issue, which we've now adjudicated, or two, the record of intertie discharges that occurred on several years as reflected in the record. So that is the two issues to be resolved for processing of these applications. And the scope of this necessarily needs to focus on, and now in 1B, in the intertie operations, and then to address what is the nature and extent of what may be available unappropriated water under the appropriate standards and definitions. And so I'm going to be a little bit of a diplomat and say, on the one hand, Mr. Becerra is exactly right. This is not the time and place. And matter of fact, it's a preclusion to reopen the 1196 or to reopen 8925 or any of the board orders. That's not within this scope, but that there needs to be an assessment as to what is the nature and extent of potentially unappropriated water in circumstances and conditions in which the intertie is operating that needs to be developed more completely. Because one of the things that needs to be understood is the record of intertie operations was acknowledged in the state board's decision in 2010. But the overall terms and conditions extent, the physical conditions was not adjudicated in that hearing. And so this is, I think, the time and place to consider what are those circumstances and what does it mean in terms of the availability of supply, the quantities, the circumstances. And I think Mr. O'Brien swings the pendulum too far, and Mr. Becerra is correct. There is a demarcation as to the determinations of the law of the river that has been absolutely determined by the board at least 4 occasions now, and it's not available for adjudication in these proceedings.
Thank you, Mr. Cooney. Mr. Pierce, I see you would like to comment. Please go ahead.
Thank you, Ms. Kunze. And actually, I have a question. We've been referring to you alternatively as Ms. Kunze or Hearing Officer Kunze. Do you have a preference?
No, I do. Thank you. But no, either is however is most comfortable to you is just fine. Thank you.
Okay, I want to give you appropriate respect, but Ms. Kunze is just a little easier than
Ms. Kunze.
Hearing Officer.
Kunze,
Okay.
I think, is actually probably appropriate pronunciation. I'm told the name is Switz. I wasn't born with it. So Kunze is probably appropriate. I say Kinsey, ignore the U, but it is entirely up to you. That's probably not accurate.
Okay. Thank you for that clarification. I'll do my best to pronounce your name correctly.
It's not, I don't know that one is more correct than the other, and either is fine. So thank you, Mr. Pierce. Go ahead.
Thank you. That's not why I weighed in. I want to point out the city of Bakersfield does not really have a strong position in this next phase because the city's application to appropriate focuses on the water forfeited by Kern Delta, not so much on the high flow water. But I do want to weigh in and point out that it's our position and our belief that whatever happened prior to 2010 is largely irrelevant to the state board's current jurisdiction and current authority over the Kern River. And I think the concern we have is there's a theme here from a number of these districts, which is really to try to get the state board not to review the Kern River, not to analyze the use of water in the river. And it's really, it's sort of this overall theme of there's nothing to see here. Don't pay any attention to what we're doing. Everything's fine. Please go away. And it's our position that that's not appropriate. The state board does have a duty to come down to the Kern River and determine the quantity of unappropriated water and to apply the public trust to the Kern River as has been requested and in fact demanded repeatedly by the public, who is really the true constituents of the state board. So and from a legal standpoint, I think Mr. O'Brien is 100% correct. The 2010 decisions were challenged by all of the other applicants. We prevailed at trial, we prevailed at the Court of Appeal, and I read that decision much more broadly than Buena Vista and the other districts. The state board only found that the Kern River was no longer fully appropriated. That was it. Everything else was left for future determination, specifically the quantity of unappropriated water. And that is what we're doing here in this proceeding. And we do thank you for your attention to all of these issues. Thank you.
Thank you, Mr. Pierce. And Mr. Becerra, I will give you a chance to respond if you'd like, but is there anyone else who would like to weigh in first on this issue? Mr. Becerra, is there anything you would like to add at this point?
Yes, thank you, Ms. Kinsey. Both Mr. O'Brien and Mr. Pierce are correct that the state board was quite clear about what it was doing in 2010. It was saying that there was water available above existing rights. We put direct quotes from the 2010 order in our statement. I mean, I can just read it. It's from pages 4 and 5 of order 2010-0010. Mr. Easton testified that water diverted into the intertie is in excess of traditionally held and exercised rights and claims of right to Kern River water, and that whenever water has been released into the intertie in the past, all Kern water right claims have already been satisfied. This water is by definition unappropriated water. The board was only talking about water above what it called traditionally held and exercised rights and claims. Those were defined in 1964. They then were accepted based on a specifically cited staff analysis in 1989. It was, I believe, confirmed again in 1994. And in 2010, there were 2 changed circumstances. That's why we're here. I don't know how the board could have been clearer about what we're supposed to be doing in this hearing. It's what is the unappropriated water above, quote, traditionally held and exercised rights. To the extent there are public trust issues, that's not this proceeding. There are public trust issues about how to allocate any unappropriated water. There might be other public trust issues, but that's not this proceeding. This proceeding specifically follows from the 2010 orders. So I don't think it's unfair to track the explicit language of the 2010 decision. And I don't agree with Mr. Pierce about what that means. The board was quite clear about what it was doing. There was Kern Delta forfeiture water and there was intertie water. That's what might be unappropriated. That's what we're here to do, not revisit the entire history of the Kern River.
May I just respond briefly, Ms. Kinsey?
You may respond briefly, and then we will be done on this issue. But yes, please, Mr. O'Brien.
And I realize this is not the time for an argument on the merits, but one of the important facts in this case, which you'll hear when we get to the hearing, is that subsequent to the 2010 decision and subsequent to the enactment of Sigma, Buena Vista substantially increased its diversions on the Kern River. And in fact, in 2017, which is a wet year, their diversions were over 500,000 acre feet, which was unprecedented. So I don't know how you address the question identified by Mr. Becerra, the question of the extent of traditionally held and exercised rights without examining the question, what was the scope of the pre-1914 rights claimed by Buena Vista? That is one of the central issues in this proceeding. And we need to address that and resolve that question. Thank you.
Ms. Kinsey, if I might add one thing, it's
You have
completely, it's
10
not,
seconds. Go ahead.
the concept of Buena Vista diverting over 500,000 acre feet is unprecedented, is simply incorrect. We attached portions of the 1964 hearing record to our statement that indicated in 1952, the State Water Rights Board found Buena Vista used 516,400 acre feet. And that was part of the basis for the 1964 decision. So it's simply not correct. That level of diversion is unprecedented under the second point right.
Thank you, Mr. Becerra. So this is what I want to do on this issue. What is now clear to me, and I appreciate revisiting this. I realize we talked about this in some detail, although at a more general level at our pre-hearing conference. It must be at least 6 months ago. I don't have the date off the top of my head, and that was helpful. We went through the phase 1A process. I think that helped me to learn more, a significant amount more about the Kern River and its operations, at least in the first point section. And here we are again today talking about these issues, but I think we've narrowed them down to some degree, but they continue to be complex. And what has become clear to me, both from your pre-hearing conference statements and then our conversation today, is that there is a significant amount of dispute about what the impact of our prior decisions are. Decision 1196, the board's decision in 2010, addressing the fully appropriated streams declaration. It is not clear to me from the face of those decisions, the scope of the issues addressed by the board. I do not think it's clear. I think to some extent, to understand what the board did in those proceedings, I would need to understand and look at the complete evidentiary record, which I'll tell you at this point I have not done because they're significant. I think you phrased the issue well, Mr. Becerra, for me, which is that one of the questions here is what is the appropriate analytical baseline for determining what unappropriated water is? I think that is one of the primary questions that we should address in phase 1B. It's one of the issues, and I don't know what the answer to that is. And I think the answer to that will likely be affected by what the scope of what the board decided in its prior decisions. And I don't think that is a decision that can be made without evidence, without more understanding and more argument and assistance from all of you in clarifying to me what the board did. I also think these issues will hopefully clarify themselves to the extent that particular matters are actually raised by Kern Water Bank Authority or other parties. Right now we're speaking in the hypothetical. I mean, there's a lot in Kern Water Bank's complaint, which is not officially on, or at least explicitly on the table in this proceeding. So I would like to see what issues are actually raised, and I think that will help me clarify the issues. So what I'm coming down to is I see phase 1B. I'm not inclined to change, at least on this basis, the scope of the issues in phase 1B, but I will encourage all of you to make these arguments in your opening briefs and possibly again in your closing briefs, because they are important to me. And it may be that evidence is introduced by Kern Water Bank Authority or other parties that I then consider to not be particularly relevant after the fact, after we've heard all about it, because I find that decision 1196 or the board's 2010 decision put sideboards on what it is we're doing in this proceeding. But I think we need to go through that exercise, and I need more information about those evidentiary records and what was actually decided. So I'd like that to be on the table. So I'm deciding to some extent not to decide right now, but it's because I think these are issues that are legitimate issues and that should be addressed in this proceeding. And I think it is certainly an issue on the table for me to consider what it is that I have been tasked to do in presenting a proposed order to the board on the issues that have been assigned to the Administrative Hearings Office. And Mr. Jacobs, you noted that this has some relationship, I think, to the water availability analysis, and we'll get to that next. But are there any questions at this point, before we move on to talk about phase one, the scope of phase 1B and the water availability methodology, if you will.
Yes, Ms. Kinsey, if I might.
Yes, please. I see your hand. Thank you. You have a Zoom hand up.
I try. I won't sound very good at it even now, but I try. So I appreciate your concern for understanding exactly what the water board has decided in previous orders. What that raises in my mind is that each of those orders has a distinct hearing record. And theoretically, we could have those records available and the parties could just submit briefs as to what they mean. That is a radically different proposition than all of us presenting what would be a mountain of evidence if we proceed directly from where we are now to all presentation of all evidence that might be within the scope of the issues in the hearing notice. I suspect you then would receive a barrage of evidentiary motions and objections to that pile of evidence. Let me suggest one approach to you. It's not in any of the hearing statements, but if the water board could simply make the hearing records available for the prior orders to all parties, and then we simply write briefs, and then you could decide what the scope is, that might be a productive exercise. I fear for your sanity at the scope of evidentiary objections you will receive if we just proceed directly into a hearing at this point.
Thank you, Mr. Becerra. Here are my thoughts on that, because something like that occurred to me. I think, and Mr. O'Brien, I'll look to you to weigh in on this, but I think once again, these issues tie in with what issues are actually going to be on the table. It seems to me that it is complicated to talk about water that makes its way into the intertie and the relationship to the scope of pre-14 water rights. I'm not sure those two things can be disentangled in advance, because I guess what I'm trying to say is, I don't know that we can disentangle this question of the scope of the board's prior decisions with the issues and the evidence actually on the table in this proceeding. And my attempt to do it, I think, will raise just as many complexities as dealing with what I anticipate will be evidentiary issues. On the other hand, I think, and now that I'm thinking and speaking at the same time, which is risky, but I anticipate there will be a number of evidentiary objections. However, based on defining the scope of phase 1B to include all of these issues that are on the table, as I said, it may be that I find certain portions of evidence are not particularly relevant to the outcome of the decision because I make a particular legal ruling as to the scope of the underlying decisions after the fact. But I think we need to proceed forward. We could proceed on this in numerous phases. We've already attempted to break this down to several phases, which I think is a good idea. But otherwise, I would like to move forward, and I think there's going to be a significant amount of evidence no matter what we do. And I don't want to limit the scope of this proceeding in a way that is inappropriately narrow. I think there's an opportunity to narrow the scope of the decision once all of the evidence is in. Mr. O'Brien, do you have anything to comment on? Do you have any comments on this?
I think your last point is really a critical point, Ms. Kinsey, that I don't think you want to do anything at the front end of this hearing to unreasonably limit the scope. I think that would be, it would create risks for everyone that at some future point that might be questioned. I think it's best and safest to basically leave it as the hearing notice has stated it. If Mr. Becerra wants to bring in evidence from the earlier 1964 hearing process, we can deal with that at the time. I don't personally think that's particularly relevant to what we're dealing with here, but we can sort that out at the proper time. But we are prepared to present evidence on the issues identified in the hearing notice, and I think that would be the best way to proceed. I would say that we did suggest in our pre-hearing conference statement that pre-hearing briefs not to exceed 15 pages might be helpful to the hearing officer, and I still believe that. There's clearly some complicated issues here, and while we won't be able to completely untangle them in 15 pages, I think you would at least get a pretty good snapshot of the positions of the various parties on the issues we've been discussing this morning. I think that might be helpful to you.
Mr. Cooney, did you care to comment? I noticed you're off mute.
Yeah,
Go ahead.
I am, just briefly, and I think a pre-hearing briefing addressing these issues will, I think, be helpful for you to discern exactly the nature and the scope. And I think that would be advisable before you go to what could be a very complicated, unnecessarily so complicated, of going and taking the entire records of all of the proceedings of the Kern River and bringing that forward. I think you should maybe proceed in layers, and that briefing, I think, will actually be very guiding to you in terms of what the scope is for this proceeding appropriately based upon the actual language of the orders themselves from the board.
And Mr. Cooney, will you clarify for me, in your mind, do you see this pre-hearing briefing as separate from a pre-hearing briefing on the substantive issues and the evidence, or just one combined pre-hearing brief, or you hadn't thought about it in detail?
Yeah, I'm certainly not thinking of them in the context of as we have in 1A, where we have actually done extensive briefing of law and facts and record. It's rather really more of these threshold issues of what is the legal scope of these proceedings in light of the prior orders and in light of the assignment, et cetera, really on the language of the orders themselves, without us having the record yet developed.
Thank you. So that is what. So what I'd like to do is go forward with the scope of Phase 1B as is. I think it does make sense to have pre-hearing briefings. I mentioned that before, but yeah, I do want that. I think what we will do is we will set a pre-hearing conference shortly after the submission of cases in chief, whenever we find that to be as a check-in, because frankly, I think I'll know more, even having not had a chance to go through all of the evidence. I'll have a bit of a better understanding once those initial submissions are in. So let's do that. We'll set a pre-hearing conference after the submission of cases in chief. We may need more than one. And then we will also certainly set deadlines for pre-hearing briefs. What I've seen is in the suggestion, we'll come back to this, but what I've seen in the suggestions is 15 pages, and we'll talk about a deadline for that and whether 15 pages is appropriate. At this point, I'd like to move on to the issue about the water availability methodology that Mr. Jacobs, I believe you raised on behalf of your client in the pre-hearing briefing. I think you asked me for clarification. CDFW also asked me for, there's a lot of asking me for clarification, which is, I guess I haven't been clear, but to the extent it's appropriate, I'll try to clarify. If it's not appropriate, I may defer the issue. But Mr. Jacobs, if you would please maybe refresh my memory on, or summarize for me the questions or concerns that your client had on this issue.
Okay, well, I think some of this, it relates to what we just talked about, like what is the scope of this hearing? But, the parties in this matter, most of them submitted their applications in 2007. I think Rosedale's was in 2010 or shortly thereafter, but, and then they went quiet for a while. And then in 2018, we received a letter from the state board saying it's time to, get going on this. And the letter explained that the state board wanted us to submit a joint water availability application, and it provided a methodology. Now, the letter also said you could do it, I think they called it an addendum, and explain issues that you had, but it asked that we get together and try and work with a common data set and present a joint water availability analysis on the methodology requested. And we did that, and it took almost a year. It was expensive. It involved multiple meetings with the engineers and the attorneys. And it involved, I think, at least 2 trips by the engineers to the state board to meet with staff along the way and confirm that we were doing it correctly. And it was in August of 2019 that was submitted to the state board. And that analysis found that there was water potentially available in 12 months out of I think it was a 1,503-month record. Our question is, I mean, we were asked to do that. Where does that framework stand? Where does that methodology stand? And I think you've heard today some of the other parties having a bit of a hard time here grasping what you want us to present. And so I'm asking for your clarification on, is that the methodology that the board is considering? Help us understand where that stands.
Thank you, Mr. Jacobs. I'll go ahead and respond, but this is not going to be the end of the discussion. Ms. Murray, I see your hand is up, but let me respond as to what I'm thinking, because this may help narrow the discussion, which is I see part of this proceeding as including on the table what the appropriate methodology is to assess water availability for purposes of these applications. The division took a certain approach in the letter in 2018, which may ultimately be the most appropriate approach based on the record and the evidence, or it may not be. I will point out, I did notice that it appeared to me, and we're getting into the substance of the letter, which is more appropriate for the hearing, but I'll just point it out for all of us. I believe the letter refers to Water Code Section 1260 Subdivision K, which is a different Water Code section than is what is included in our hearing notice with respect to water availability. It may be that the standard is different there too. So I think there are some distinctions. So the shorter answer is, I think that methodology and the appropriate methodology for assessing water availability is on the table. And this, at least from my perspective in presenting a proposed order to the State Water Board, my understanding is part of my role during this hearing is to consider an appropriate methodology for assessing water unavailability and to apply it in this proceeding. And that may or may not track exactly the direction of the division in the 2018 letter, although I certainly anticipate that the work that has been done will be helpful and relevant in this proceeding. So we'll go to that. But Ms. Murray, do you still have comments? Would you like to comment on this issue?
Yes, and I just note that at least State Water Board staff has applied water availability analysis to another Central Valley River, where they did request information on what water is needed for fish and wildlife resources. Before a permit can be granted, Water Code 1375D does say that before the water board can grant a permit, they have to find that there's unappropriated water. Water Code 1243 requires that there be in that calculation a determination of the amount of water available. The board shall take into account the amount of water required for preservation and enhancement of fish and wildlife resources. So I do think this is all part of the question of water, what water availability analysis is appropriate. And as we know, with one other Central Valley River, there has been staff that have requested that preservation and enhancement of fish and wildlife resources be factored into the water availability analysis presented by the applicant.
Thank you, Ms. Murray. Is there anyone else who would like to comment on this issue? Mr.
This is
Cooney, I see you, Mr. Cooney, and then Mr. O'Brien. I also see you came off mute. So Mr. Cooney first.
brief comments. My first one is that we learned from our participation in the phase 1A process that it's hopefully most facilitating to your efforts to try to directly respond to the issue as you've defined it and to try to provide you the information that you've identified. And we've done that in 1A, and we'll endeavor to do that in 1B. I also would say that, Mr. Jacobs is right. The work that was done in the law that was submitted in 2019 was exactly that. It was directly responsive to the particular instructions of the staff, and it was appropriately presented but it's never been reviewed upon. And so it may be relevant to this, as you indicated, but we will try to focus as best we can on the issues that you're now identifying, because they're maybe related, but they're different. They're stated differently, and we're going to try to be as responsive as we can to you. And then I guess my next comment is really coming in response to the Department of Fish and Wildlife, and that is, I think the already existing orders, legal ruling orders, and actually your notice clearly delineate, the timing and particulars of when it's appropriate to properly consider the public trust resources issues. And Ms. Murray correctly stated, the first predicate is actually an affirmative determination of unappropriate water as a requisite. That's a Temescal case, Supreme Court case. And then you've identified the other requisites and timing issues on page 6 of your notice as to when and how these will be considered in a general sense, not in a particular sense, because you don't know yet. No. And we certainly stand by and agree with that characterization. And I think there's a little bit of a difference in what Ms. Murray was suggesting, is that actually public trust resources need to go into the equation before you even know that there's unappropriated water. And I think that's not correct.
Thank you, Mr. Cooney. Mr. O'Brien.
Yes, I'd just like to state for the record that the Kern Water Bank Authority agrees with your statement that the appropriate methodology for determining how much water is available for appropriation is a live issue for Phase 1B. I think all the parties will have an opportunity to present evidence addressing that issue, and ultimately it will be your job to decide what is the appropriate methodology. Thank you.
Mr. Pierce.
And Ms. Kunze, I wanted to point out that some of these issues that have been raised over this issue or over this, the WAA, I think you've already addressed those issues in your November 3 ruling. In fact, you indicated that if a party claims that they have a right to divert water, and which is really essentially what Mr. Jacobs is saying, he's basically saying, like, everybody is diverting the water already. Again, there's nothing to see here. Please go away. There's no inappropriate water. And you ruled in your November 3 ruling that you're still empowered and authorized to investigate whether the use of water is in fact valid and whether the water is being diverted pursuant to a valid right. So the point is, just because their WOA says there's no inappropriate water, that's the start of that's not the end of the discussion. That's the start of the discussion. I think people have to demonstrate that they actually have a valid right, and in fact, they also have to still, it's our position, take into account public trust issues and considerations. I also strongly agree with Ms. Murray, and I know we're not quite at the part of today where we're going to talk about public trust, but I think you're going to hear a familiar theme from the city of Bakersfield, and it's really our strong position that you actually have to have a separate hearing on public trust after Phase 1B before you make any water allocation decisions, even a preliminary decision. And it's our position that the public trust needs and demands have equal or greater value than any claim to the water that would be asserted through a WAA or by one of the applicants. Thank you.
Thank you, Mr. Pierce. Mr. Becerra.
Yes, I just want to note my strong disagreement with Mr. Pierce's statement that all rights need to be fully reconsidered before you can determine whether there's any unappropriated water. That appeared to be what he was saying, that we all have to prove that our rights are valid before we do anything else, which I don't think is the slightest bit contemplated in the 2010 order lifting the FAS declaration.
Thank you, Mr. Becerra. And Mr. Jacobs, I think I've been fairly clear, but I do want to give you a chance if you had any follow-up on this issue before we move to the public trust issue.
I guess just briefly, the law of the river rights are re judicata. The state board's already considered them in 1964 and in 89 and again. And that's not a small thing. In fact, let's say that we go through the whole process again here and you make an order and it's upheld and we get a final ruling. I mean, under Mr. O'Brien's reasoning, 10 years from now, we would have to go through the whole thing again if somebody else filed an application. And then again after that. I mean, this is the law of the river rights have already come before the board and been ruled on in this exact kind of a proceeding. That's what D1196 was.
Thank you, Mr. Jacobs. I look forward to your briefing documents on this issue, and we will hear from you more on this, I'm sure. I would at this point like to move to the public trust issue. I know I have addressed this in other documents, but I realize it's an important and just like the other matters we've already discussed this morning, an important issue I will try to clarify to the best of my ability with the knowledge that some of this remains to be seen. But first, so I'll turn to Ms. Murray, and then I imagine Mr. Pierce, you may have comments on this issue, and then I will look to all of the rest of you if you have comments. But Ms. Murray, would you like to open? Is there anything you'd like to add on the public trust issue and the scope of phase 1B of this hearing?
Well, in our pre-hearing conference statement, we really just asked some clarifying questions. We understand that public trust issues will not be in phase 1B. There will be apparently a live issue of the water availability analysis and what that needs to include, which the Water Code does require Fish and Wildlife, which is a subset of public trust. So we'll understand that issue may be in 1B, but separate. It seems to me that there will be a subsequent phase for public trust, and so we just wanted to, if to the extent that you have that plan already in your mind to try to find out for our edification when would you get to public trust, and preferably in the AHO phase and not when it goes back to the water board.
Well, let me ask this, Ms. Murray, because it's an issue that I think I've raised a number of times, and I'd like to talk about it. We're all here. One of the issues that seems problematic to me is that the public trust issues raise questions that I don't think at this point in the application process we have the information to answer. I mean, we don't have a CEQA document, we don't have EIRs for any of these proposed projects. We haven't even gone through the protest process. These applications haven't yet been noticed. So we don't know we don't have the world of potential protestants. And even if we were to go through a full public trust consideration with respect to these applications, it seems to me that the board might be in a position of having to do it again down the road, because at the point in which these applications have been noticed, at the point at which EIRs have been completed for specific projects and specific proposals. Is that your view of how this would need to go? Or is your proposal that all of the public trust considerations could be wrapped up in the AHO process with respect to these initial questions of how much water is available for appropriation under these applications?
I don't think we have a definite viewpoint. At this point, we're still trying to wrap our head around, I'm still trying to wrap my head around what might be the outcome of phase 1B, because what we don't want to see is a finding of, okay, there's this much unappropriated water, and others feeling pre-14 or otherwise feeling like they can then just start diverting that before the public trust is considered and factored into that, what needing that certain amount, which it does not have any rights right now. And I appreciate Mr. Jacobs saying that 1964 there was a determination, but as we know from National Audubon, that water rights are usufructuary and that they do get reevaluated as times change. And we haven't had a public trust hearing similar to the National Audubon type of hearing for the Kern River. So I don't know that the department has a position about at what point, but wouldn't want to see some definite statement about water being available for diversion before there's the in-stream fish and wildlife required by the water code. And that's where it's like there's available and there's available for diversion. And we think there's a distinction there.
Thank you, Ms. Murray. Mr. Pierce, I'll turn to you next.
Yes, thank you. Thank you, Ms. Kunze. And again, I do agree with Ms. Murray, and I do think it is appropriate and in fact required to have a separate hearing just on public trust issues, needs, and demands after the phase 1B hearing before you make any kind of decision, even a preliminary decision on the quantity of unappropriated water, whether it be forfeited water or high flow water, as Ms. Murray indicated. And I think in terms of your concern about, whether people are prepared or whether they've done CEQA, I will point out the city of Bakersfield has prepared an extensive and detailed EIR in support of its application. Again, it's a programmatic EIR, but it's only programmatic because we were still waiting to find out how much of the forfeited water was going to be considered unappropriated water. But that EIR has been certified, it's been challenged in court and upheld, and we're ready to move forward with a public trust hearing. I would also point out that you have in front of you some of the best legal minds in the state of California, some of the most experienced attorneys on water law, people who have been doing this for decades. You also have Mr. Keats, who has a roster of environmental biologists and staff people and resources that can come before you and present all the issues you need to consider on terms of public trust. There's no reason to delay this. And I don't think the district should be rewarded for not doing CEQA, especially when Bakersfield was ahead of the curve. And I will point out, I believe the Kern Water Bank did prepare an EIR also in support of their application, although I'm not sure of the status. I think it was challenged in court. But again, I just want to strongly emphasize that the board should have a separate hearing just on public trust after phase 1B, whether it's a phase 1C or phase 2, before the board issues even a preliminary decision on the quantity of unappropriated water. The issues are so important, they shouldn't be delayed. We're ready to go. Everybody else can and will be ready to go if that's what we're going to do. Thank you.
And Ms. Kinsey, this is Adam Keats. If I could jump in, I'm sorry I'm not on video.
That's okay. Thank you, Mr. Keats.
Yes, and I really appreciate Ms. Murray's and Mr. Pierce's comments, and we join with those comments. I'd make 3 short points. The first is that the problem with the current setup in our perspective is that it assumes that public trust considerations are subservient to the other considerations that are being addressed in the hearing. And as Ms. Murray said, in the Audubon case, the Supreme Court's made it really clear that public trust considerations are not subservient. They, in fact, supersede all the rest of these considerations. They should be the primary and initial and the first hurdle that everyone has to get over is considering what the impact of their actions are on public trust resources. And that leads into my second concern with these proceedings and with your statements about the role of environmental review, specifically regarding CEQA. And I say this as someone who has practiced CEQA for, litigated a lot of CEQA cases for 20 years. I don't think that the CEQA proceedings or the CEQA process and an EIR process is necessarily is a necessary component to a public trust analysis in these proceedings, or even before the water board. The problem with the CEQA process is that it's going to be project-based. It's going to be initiated and controlled by applicants or by agencies that have specific projects in mind, and they're going to limit their CEQA review and their CEQA analysis to the projects and the actions that they perceive their projects to be taking. It's not going to lend itself to none of those processes. And I appreciate that the city of Bakersfield has already done their CEQA analysis for their application, but even that's too limited. All those processes are going to be disjointed, segmented, and boxed up and squirreled away, and by design are not going to be addressing what this agency's obligation is to address, which is the public trust implications of humankind's interaction with this river system. And that's what's happening right now. Is we're watching the creation of a system where everyone's kind of going down, we're making little micro decisions that are leading us into a little zone of avoiding the problem or avoiding the issue, or not addressing the actual issue that needs to be addressed. And the third point, I think, is that what Mr. Pierce said, I think, is very accurate. We have a moment here where the public interest groups have been able to coalesce into a coalition, have been able to marshal some resources, have legal representation, have scientific expertise on tap and ready to go, have expressed an interest in participating on this and educating you and then educating the board and participating in these proceedings. And the history of water law in California is by design to eliminate the voice of these interests. It's too expensive, it's too lengthy, it's too obtuse. Everything that's happened in these proceedings so far have been according to that game plan. And we might not have another chance to do this. I know the rest of the lawyers for the water districts are going to have plenty of funding for plenty of time to be able to participate in lengthy, incredibly long proceedings that are going to last another 10 years. I don't think the public interest has that kind of time. We have the window right now, and I urge you to reconsider the way you structure these hearings so far and to recognize the impact of what you've done so far on these interests.
Thank you, Mr. Keats. Before I respond on these, I'm going to turn to all of you. I think some of you may have comments on this. I anticipate, Mr. Cooney, that you may have comments. So I will turn to you first, and then I will ask if there's anyone else.
Thank you very much. Two short comments. One, I think as you've articulated in your prior orders, and for that matter, even the state board's acknowledgement in the petition process that we just recently reviewed with regard to the city of Bakersfield, and then also in your notice, pages 5 and 6, I think you have it exactly right, is that first there has to be a determination affirmatively of unappropriated water to help us understand what it is that we're talking about. And I'm talking about now in public trust realm. And then I think each of the elements that you've identified, that there would be a potential noticing process, there would be a potential protesting and resolution process ideally. And then there is also a potential in CEQA process that needs to be followed. And all of those are really edifying to really understanding what it is that the resource needs are in a particular context. It can't be done in a vacuum. So you need all of these facts, and we simply don't have them yet. And then my last point will be very brief, and we hear this repeatedly, but I just need the record to be clear. Mr. Pierce's representation that his CEQA document is complete and ready to go is very misleading. In fact, it was programmatic, and in fact, it did not even address what would be the consequences of the reallocation of water that he is advocating for. And that was acknowledged. And matter of fact, he's advised that he has to represent to this board that it is not complete. So I'll just rest right there.
Mr. Becerra, I see you're off mute. Is there something you would like to say, please?
Yes, just very briefly. Ms. Kinsey, I think you stated the matter correctly at the beginning. This proceeding is about certain water right applications. First, the issue is whether there's unappropriated water available to them. And then under the water code, it is of course the case that the water board needs to consider certain factors, including environmental factors, before issuing a permit. So, we're, as amazing as it is, we're kind of at square one on that process. It's a radically different proceeding to say we're going to reevaluate everything on the Kern River. That's not this proceeding. I mean, I certainly disagree with Mr. Keats's interpretation of National Audubon, but that's not overly relevant. The issue is that this proceeding is about certain applications, what water may be available to them. And then there is a whole process, as you said at the beginning, of protests and protest resolution and possibly a hearing about how much to actually allocate to any new permits. So I think we're well away from that kind of proceeding, as Mr. Cuny indicates. You would be having a completely different kind of hearing if what you're going to do is say, we need to reevaluate everything on the Kern.
Thank you, Mr. Becerra. Any other comments? And I will, I'm going to express my thoughts and then I will turn back to Ms. Murray, Mr. Pierce, and Mr. Keats if you have anything else to add. So I think what I'm hearing today, and just we've talked about this a fair amount before, are two distinct issues. One is, related, but one is this request or urgency expressed to consider the impact of water diversions on the Kern River system overall, and the global impact. And in that respect, I don't think that's a matter of my discretionary authority. I don't see myself in this proceeding or the Administrative Hearings Office within the scope of our assignment as having authority to address those issues. There are certainly significant arguments on both sides about whether those issues should be addressed now, the urgency and the importance of those issues, but I don't see myself as having the authority to address those larger issues about water diversions overall and the impact on the Kern River system and the public trust resources as part of this proceeding. I recognize Audubon imposes obligations on the State Water Board. Nonetheless, I don't think that is a matter within my discretion, within the scope of the assignment that has been made to this office by the State Water Board. So I do see that there are limitations on the scope of this proceeding and that this proceeding is focused on these particular 6 applications that are at issue and that are before us. So with that, I think the second issue is how should considerations of public trust with respect to the impacts of those applications and proposed diversions of water or, and those proposed diversions of water, what those are and at what point should public trust considerations be made with respect to these applications. That I think is a matter that is to some extent within my discretion, also acknowledging that the entire Kern River applications were not assigned to this office in full. There were specific questions that were referred to us with, I think, the anticipation that the applications would then be referred back, if you will, to the division for further processing. I think to some extent the outcome of this proceeding may affect how that process works exactly, but that's my general understanding. So I do think there is room for discretion within that scope of when do we consider the public trust and the nexus with these particular applications and these particular proposed diversions. And that, of course, was the basis of my question about whether we have a sufficiently developed record to address it now in a way that would not require the State Water Board to revisit the issue down the road and essentially hold a second proceeding once all parties were noticed and the record was on the table. I tried to be clear about this issue in the hearing notice. It's a tricky one to articulate, so I appreciate that we can talk about it again today. what I envision is that any decision, a proposed order that comes out of this proceeding by the AHO would acknowledge that public trust resources and the impact of these proposed diversions on public trust resources has not been fully considered. So for example, if the outcome of phase 1A and phase 1B is to find that there is some amount of water available on the Kern River that is not being diverted pursuant to existing valid rights, that any such finding would be caveated that public trust resources have not been considered, and it may be that that water is required to be dedicated for public trust purposes. I anticipate, depending on the evidence that comes forward, that actually going through this proceeding will help us narrow the issues under consideration, because it may be that that flows are only available during certain periods of high flows, very high flows, and that may affect the scope of public trust considerations that we would need to look at. My general plan is to address, with that caveat in mind, that in the assessment of whether water is available for diversion under these applications, we're first going to look at existing valid rights, the amount of physical water supply, and then later turn to public trust uses. As I've mentioned in my rulings, I do think that what I'm calling phase 2, I'm not sure how things will play out, but what I'm calling phase 2, which addresses this assignment from the board to provide a recommendation as to what order, in what order these applications should be processed and how any available water might be allocated among them. I do think that that seems to implicate public trust considerations to some extent. So I do anticipate that that would be the phase in which evidence related to public trust uses comes into this proceeding. And that would be after phase 1A and phase 1B, and we would then turn to those issues in the context of phase 2. Once again, I see the limits on the scope of this proceeding as being specific to these applications. So I do not anticipate that that proceeding would be one in which we would be analyzing the overall impact of diversions on the Kern River system, with the exception that we have to acknowledge that the impacts of these proposed diversions under the applications, their impact on public trust resources may be cumulative would be cumulative with respect to existing diversions on the system. So that is where I'm coming from on this, and that is what I've tried to articulate. I do want to caveat very clearly that any decision coming out of this proceeding, or proposed order, I should say, because it wouldn't be a final decision until it's adopted by the board, would be contingent on consideration of public trust resources before the board can act to grant any of these applications. Now, on the other hand, it may be that we go through this process and find that there is virtually no water available for appropriation and diversion, just based on this analysis, public trust resources aside, and then it may become a moot issue. So, which is part of the reason I think we want to proceed with phase 1B and then reassess where we are. So that is my thought, as we proceed with phase 1B. Maybe at that point, it would be important to reassess. Another issue on the table that we have not decided, and I don't think we want to decide today or address in too much detail today, is at what point I would be submitting a proposed order to the board. Is it after phase 1B, or do we complete the entire proceeding and complete phase 2? So that is also an open question, and it may have some relevance to how we address these public trust concerns. Again, I don't think we should address it today, but it is something that I'm thinking about. So that is some food for thought. Ms. Murray, is there anything else you'd like to mention to me, or anything that remains unaddressed?
Well, I thought I understood until the very last comment, because what I heard was phase 2, the public trust issues when deciding how to allocate water among the 6 applications. Which indicated to me that you probably wouldn't try to have a final order after phase 1B, but I guess if you find there's no water available then at all, then a phase 1B would go back to the board. But am I correct that if you do determine at the end of phase 1B that there is water available, then that would then lead to a phase 2 to how to allocate that among the 6 applications, and then public trust would be an element in phase 2 in terms of how, as we decided, Water Code 1243 requires that before a permit's issued, you take into consideration Fish and Wildlife. Is that?
Let me attempt to clarify. Let's see.
Sorry.
I think, no, these are good questions because I think there may be I know there's a lack of clarity. I fully intend, unless the State Water Board calls me off, to address all of the issues that have been assigned to the AHO. I think one of the questions here is whether or not the presentation of these issues to the board for purposes of presenting a proposed order and obtaining a final order from the board, it could be done in one final order that occurs after all phases of the proceedings, and that addresses all of the issues assigned to the AHO, or it could be broken down into parts where a partial proposed order, if you will, would be presented to the board on phase 1A and phase 1B, and then later, after we've completed phase 2, an additional second part of the order would be presented to the board after phase 2. I think their arguments have been made by the parties both ways, that it is helpful to some extent to have clarity on the first issues before proceeding to phase 2. And then there are good arguments the other way to say that all of these issues are related. They should be considered collectively together at one time, and we shouldn't break them down into an attempt to separate them out, and that confuses things. At this point, I have not made a decision as to at what point to bring a proposed order to the board, whether to do it in one or to do it in 2 parts. Does that help clarify, Ms. Murray? I want to be clear because I think that's still an issue on the table, and I have not made a decision.
That's helpful.
Is there anything else you'd like to add, Ms. Murray?
Not at this time.
Thank you. I will turn to you, Mr. Pierce, and then Mr. Keats.
Thank you, Ms. Coonsey. And I want to be clear, we're not necessarily asking for you to do anything beyond what you've been asked to do by the board. It's our position, though, that under Audubon, under National Audubon, if you're making a water allocation decision, you have to consider public trust. And that is something that's necessarily within the authority granted to you by the board. It's within the scope of your review of the Kern River. And really, we're really only asking for one specific procedural thing, whereas we're basically just saying, don't make any decisions on the quantity of unappropriated water, whether it be forfeited water or high flow water, until you've looked at the public trust issues. And you've raised yourself, you're not sure when you're going to make an order, and we would submit that there's no reason why, in fact, every reason why you should delay a decision on the quantity of water until you've considered public trust, albeit perhaps it's just in the context of the issues in front of you. But we're not asking you to do anything beyond what you've been asked to do. We're not asking you to do anything unusual. You've acknowledged repeatedly, and the board repeatedly acknowledged, that public trust is going to be considered. We've raised the concern that you do that along with all the other considerations, all the other evidence you're considering, look at public trust at the same time. And it does seem appropriate for a separate hearing before you issue any kind of decision. That's the point we want to make.
Thank you, Mr. Pierce. And I also just wanted to acknowledge that I realized that the city of Bakersfield's interests, and I didn't mean to inappropriately collectivize the city of Bakersfield and the public interest groups and CDFW. You have, to some extent, aligned interests, but I realize your respective clients' interests and mandates are distinct. So thank you for that clarification.
Thank you, Your Honor. Or thank you, Ms. Coonsey.
Mr. Keats.
Yes, and I appreciate those clarifications. Those help me greatly. I just have one further request of clarification. So my understanding then from what you're saying is that if you determine that there is no water to divert because the law of the river or any other such rule or whatever means that the water has already been appropriated, there's no water to appropriate by anybody else, none of these applications can be fulfilled, then there will be no public trust inquiry made there during these proceedings. Am I correct about that?
I think that's right. But I believe that would be accurate because we would have addressed all of the issues that are live that have been assigned to me for purposes of this proceeding. And I don't think there would be anything left to do, if you will. So yes, I believe that is my understanding.
Okay, no, that's great. And I say this, and maybe it's not obvious to everyone here, but it's an important question for us to know the answer to based on our limited ability to allocate our resources. So there's a possibility of some public trust issues being raised. If there is water to be found to be able to be diverted, then at that point there's the possibility of some public trust issues coming up. But at least in the scope of this next phase 1B, which concerns only the question of whether there is water to be diverted, we should not anticipate public trust issues to be raised during these proceedings.
I don't anticipate any. Now, I've never ceased to be amazed by what might, the complexity of California law and California water law. So I don't think so, but of course, it's not my position to make any promises as that evidence comes in and the argument comes in. In thinking about whether, I can't think of a particular nexus, but as I said, that's only based on my experience and my knowledge.
That I understood, and never underestimate the power of the capacity of attorneys to insert issues into any proceeding. But all right, that's very appreciated. Thank you for that clarification.
Right, and I don't mean to suggest that it may not be relevant in a way that I just can't comprehend right now. So
right,
they
of
may
course,
be perfectly appropriate arguments. Yes. Anything else, Mr. Keats?
No, thank you very much.
Thank you. Are there any other comments on the scope of the phase 1B proceeding? I almost hesitate to say it, but this is the time and the place to raise them. Are there any other comments on the scope of phase 1B before we move to the more mundane procedural issues like scheduling a hearing? And maybe what I'll do is I'm going to actually let us take we'll do a 10-minute break before we turn to those issues, but I just want to look around the room again. Anything else on the scope of phase 1B? All right, let's take a 10-minute break for all of our sakes, and then we will come back and look at scheduling a hearing, scheduling deadlines, and working through those issues. So I'll see you back at 10:40. All right, it is 10:43. Let's go ahead and get started. I apologize, I'm late. I was lost in my calendar. And I realized I should confer with all of you on what we're doing next. So on the agenda, I think it may make sense to some extent to talk about these all at once. We need to set hearing dates. Those are hearing days for case in chief and rebuttal. I think it makes sense in this proceeding to separate the case in chief and the rebuttal and have some time in between. This is significant. This is sufficiently complex. I think it will help me, and hopefully it'll help all of the parties. But if you have a concern about that or don't think that's the way we should proceed, please let me know. I think there was one request in at least one of the pre-hearing conference statements that the submission of rebuttal evidence, the deadline for submission of rebuttal evidence be at some point after the case in chief hearing days. I'm open to that idea, so I would like to hear about whether we should do that. And then, of course, we have all the other deadlines for evidentiary motions and things like that. And I appreciate the hard deadlines suggested by some of you in your pre-hearing conference statements. I realize that the dates themselves may change, but I think the timing of those as they relate to one another and relate to the hearing days is very helpful to me in understanding what you think may be reasonable. So we will talk about all of those things, but first let's focus on setting days for the case in chief hearing, but I'm going to turn to Mr. Becerra, who has a hand up. Do you have a different issue or a comment on this issue?
I have a comment on this issue. Thank you.
Great.
You earlier today suggested an idea that struck me as very reasonable, given your perspective on the scope of case in chief evidence to be submitted. I think what you need to do is see the evidence that is submitted and then decide what kind of hearing you want to have and when. I suspect you will get a very large volume of evidence. It will tell you a lot about what this hearing might look like if you proceed forward with that full scope. And before we get into setting hearing dates and rebuttal dates and that sort of thing, I would suggest, consistent with your previous suggestion earlier, you set a deadline for the submittal of case in chief testimony. You set a briefing deadline a couple of weeks after that, and then you have another pre-hearing conference to decide what you want to do. Because I do suspect you'll get quite a volume of testimony, and it may be sort of all over the map in terms of scope and subjects at this point. And I'd suggest you do that before we get into setting hearing dates and rebuttal dates, and particularly deadlines for motions for submittal of evidentiary motions. I think another pre-hearing conference would be beneficial after you see the case in chief evidence.
That's helpful. Thank you, Mr. Becerra. Of course, my primary concern with that approach, I think there are a lot of merits to it, but my primary concern is, of course, if we don't set hearing dates and set aside time, then our schedules get busy, particularly as we run into the summer. So I don't want to drag this on. On the other hand, I do hope that as we proceed down this road, things will become a little more clear, and we may want to modify our approach. That's possible. So I do want to be open to some flexibility. So I guess the bottom line of what I'm saying is I do want to schedule dates and set aside dates for us to hold at least some portion of this hearing, and do that today, so that we have holds on our calendars, because there are quite a number of us, and I realize we need to reach out. I acknowledge in my initial January 12th hearing notice that was ambitious to attempt to set dates. I am very appreciative that we almost managed to do it with the April dates, but we do need to set something so that we have it all on the books. But keeping in mind that we may want to modify this process as we go forward. On that, who would like to speak next? Mr. Cooney, you're quick with the unmute. You're next.
Very quick with my button there. Thank you very much. And I agree that we do need to set dates, if nothing more, just to get holds, as you said, on our calendar. That's so complicated to do. And in that spirit, and I know we're thinking of case in chief and then some distance and then a rebuttal case. Just for your equation, I run into hard dates if we get into hearings, whether they be case in chief or rebuttal, after May 20th. I'm good through May 20th, but then the next couple of weeks I'm out of state and I can't change any of that. So, and I'm sure all of us have other things, and I apologize for jumping to that, but that is a sort of a barrier that I have, and hopefully we can work within that, within the structure that we've talked about. I have no difficulty with one, certainly accommodating Mr. Pierce. I think that's exactly right. And then obviously your schedule. So, now it sounds like case in chief is towards the latter part of April. And then whatever that distance is. And again, I just wanted to give you I've got my own predicament of the week following May 20th. For 2 weeks, actually, I'm unavailable for hearings.
That's helpful. Thank you, Mr. Cooney. I'm scrolling through so it looks to me that May 20th is a Friday. Does that seem accurate to you?
It is. It is.
Okay. And then for 2 weeks following. I wonder, I hesitate to get into June because calendars become more difficult, but I wonder if it makes sense. It may make sense for us to schedule the case in chief portion and then have the rebuttal portion at some time sometime in June. But let's talk about that some more.
Ms. Kinsey, I think that makes good sense. And the one point I would make is I would, if it's possible, I'd sure like to have the entire case in chief hearing in one block so that we don't have to start and restart. And it sounds, based on this morning's discussion, it sounds like we're going to need a number of days. I'm not sure exactly how many, but it sounds like at least 5 days, maybe more. But if perhaps setting that hearing in May prior to the 20th, we could get that part done and then come back maybe in early June, late June.
Well, this is what I'm looking at right now. I wonder, I have 3 days in late April 25th, 26th, 27th. And then we could block off that first week of May 2nd through 6th, which is what I was looking at possibly for the case in chief to get that started. Let me write these down. I'm flipping from my calendar to Zoom, so I apologize if I appear to be staring vacantly at the screen. It's because I'm looking at my calendar. All right, keeping in mind that we haven't said anything yet, are there major scheduling conflicts with April 25th through 27th or May 2nd through 6th with any of you?
Ms. Kinsey, this is Jennifer Spalletta for Rosedale Rio Bravo, and my client is not available April 19th through the 27th.
Okay.
But the
Ms.
first
Kinsey.
week of May is okay.
Mr. Jacobs, please go ahead.
So a couple of things. I definitely need to check on these dates with our witnesses.
Of course.
And we'll make any dates work that we can. The only thing I would request is that you give us as much time as you can between case in chief and when we need to submit our rebuttal exhibits and testimony. I think because of the different approaches there appear to be going on here, I think that may be extensive work.
And that makes some sense to me, and we'll get to that when we talk about when to schedule rebuttal, but that's why I initially thought we need a space. It would be appropriate to have a space in between and a deadline for submitting rebuttal evidence after. I mean, you'll know what that case in chief evidence is when it comes in, which is significantly before the hearing, but I recognize there may be issues that come up on cross-examination that aren't anticipated. So I think now we're down to May 2nd through 6th. So let me turn back. I just, in an abundance of caution, I would like to hold a few more days in addition to 5. So I'm going to look to the next week. maybe adding May 9th and 10th. Are there any known scheduling conflicts for May 2nd through 6th and then May 9th and 10th?
I'll only note that the week of the 2nd is the Aqua Conference, which may affect some witnesses' availability, although it is in Sacramento, so perhaps not. I don't know at this
Noted.
point.
What do you think? Is there anyone else who wants to comment on that? Is that going to significant? I mean, you know, this is fairly important, but if
Yes.
I think maybe we can, if there are witness availability issues with speakers or things like that, we could probably accommodate that. But that's helpful. Thank you. So if we were to look at that for our case in chief, I think that then puts us with Mr. Cooney's planned, with that conflict, which is fine. That puts us at least to June 6th, the week of June 6th, which would be a month out.
Ms. Kinsey, if I might, I do
Yes.
know for certain that one of our witnesses is out of the country from June 1st to July 15th.
That is a significant block of time.
It is significant. And I don't know whether or not he may be necessary for rebuttal at this point, of course, but.
Well, I'm not going to defer. I mean, we may have to deal with that issue as it comes up because I'm not going to defer this till after July 15th. And it may be, I don't know if there's a way, you know, with the scheduling that we maybe will, if it's appropriate to fit him in at some point before him or her, before June 1st. But let's deal with that on the fly. Well, not on the fly, not today. How about that? Any comments, maybe Mr. Jacobs or from any other party, on the amount of time that would be appropriate to have between our case in chief and when we start rebuttal? That's what I'm trying to think through right now.
At a minimum, a month between when we see the case in chief testimony and when we have to submit our rebuttal. Ideally more than that. I mean, 2 months I think would be reasonable for this matter.
Well, and when you say submit, you mean the case in chief, the submittal of the case in chief evidence in advance of the case in chief hearing?
Correct.
Okay.
I mean, that's really what we need to go off of.
Go over. Yeah.
For the rebuttal. They're not supposed to go outside of that, right, for the hearing. So.
All right. Well, maybe let's go back. Let's go ahead and look. We're starting our case in chief, at least based on what we've talked about so far, May 2nd. And if we do that, and we'll get to rebuttal later. Let's return back to rebuttal hearing dates. But if we start our case in chief on May 2nd, then the deadline for submittal of case in chief, I think, should be at least 3 weeks in advance of the start date of May 2nd, which would put us, let me look. I think that would put us at April 11th. Are there any objections or concerns about April 11th as our deadline for submittal of case in chief evidence?
Yes, Ms. Kinsey, if I might, I
Yes, please.
suggest you said it earlier than that to allow yourself time to consider in-depth evidentiary objections. At this point, I suspect there may be many of them.
Thank you, Mr. Becerra. As I was saying, April 11th in 3 weeks, I was having the same thought. So I believe you're right. So what I'm looking at now is maybe backing it out another 10 days. I was going to look at April 1st, but it just seems like bad luck to set it for April 1st. March 30th. March 31st is Cesar Chavez Day, so that's a state holiday. But now I'm looking at March 30th as the date for submittal of case in chief exhibits. Are there any concerns about that date?
Could I suggest April 4th? Just
Yes,
in case we need the weekend to finalize
Sure.
things.
April 4th. Let's do April 4th. All right, April 4th. I think based on the suggestions I received in some of the pre-hearing conferences, the request was for at least 10 days after the deadline for submittal of case in chief for evidentiary motions. You're going to ask me for more than that now, I am sure, and that seems appropriate. So I think at least 2 weeks, which from April 4th would be April 18th. Are there any objections to April 18th as the deadline for submittal of written evidentiary motions? And the way I've done this in the past is the written evidentiary motions are not necessarily exclusive. Objections can also be raised during the hearing. However, I think the way I'd like to structure this is that any objections to testimony be made in writing by this April 18th deadline. That's helpful to me. I think dealing with issues about witness testimony in advance of the hearing is very helpful for all the parties involved so that we know the scope of the witness's testimony before we get to the hearing day. So I would like to set that deadline for all objections to witness testimony, written testimony. And then keeping in mind that other objections to evidence could be made, to documentary evidence could be made during the hearing.
Wouldn't you want to encourage everybody to file not only the testimonial, but their exhibit objections if they can? I mean, clearly that's very informative to everyone. And
yes,
I know.
Yes. Thank you, Mr. Cooney. I'm having a chance to think through the reason we've done it. I have done it different. Otherwise, in other hearings, is we're sometimes a lot tighter on our schedule, so that there isn't as much time to consider all of the case in chief evidence. In this case, I think we'll have the case in chief evidence. There's two weeks to consider that evidence. So it would be appropriate for me to set a hard deadline for objections to that evidence. Setting aside issues, as you noted, that may come up during the hearing that couldn't have been anticipated in advance. I think that would be appropriate, and I'll give everyone a chance to respond if you would like, but I think that does make sense to me, and I would memorialize that in the pre-hearing conference order that comes out of this proceeding. So thank you, Mr. Cooney. Are there concerns about April 4th as the case in chief submittal deadline, and then April 18th as the deadline for written motions objecting to evidence?
Ms. Kinsey, I do have one question about it. It's
Yes.
not exactly about submittal of case in chief, I suppose. We have what appears to be a somewhat unique situation where Kern Water Bank Authority intends to subpoena Buena Vista's general manager to testify as an adverse witness.
Yes.
Left without any particular specifications. I assume that would go like trial testimony in Superior Court. We would have no notice whatsoever as to the subject of that and no ability to respond except to object to questions on the fly. So I would propose that Kern Water Bank Authority be required to submit something like an offer of proof in writing as to what the testimony is they seek from Mr. Ashlock on April 4th, along with the rest of its case in chief.
we have a similar issue with respect to Mr. Jacobs' listing of Mitchell Moody and Mr. McCarthy of the division staff.
Yes, yes. So this is good. I had witnesses on my list, but we are now talking about witnesses. So let's talk about witnesses and we'll get back to our scheduling. These are important issues. I did notice both of those issues. On the one hand, with respect to calling an adverse witness, in past water board proceedings, I think the way this has worked at times is that you have an opportunity to ask any questions you want on cross-examination of the witness. So those questions would come up, and cross-examination is not limited to the scope of the direct testimony. So I also noticed that the general manager, I believe, was identified as a potential witness. So to the extent he was actually called to testify by the party, then opposing parties would have a chance to cross-examine him about any range of issues. On the other hand, I think there is an element of fairness here, and it would be helpful to me to understand the subject matter of the testimony that is being sought and the line of questioning. And it would be parallel to requiring what all the other parties are required to do, which is to submit testimony in writing. I mean, not entirely parallel, but similar. So I guess I'm going to turn to Mr. O'Brien. If this procedure, the offer of proof makes some sense to me, or something like that. I don't know that that's what it is exactly. Mr. O'Brien, do you have any objections? I believe, am I right that it was your client who was going to call the general manager of Buena Vista Water Storage District? Do you have any objections to that approach? Does that make sense to you?
I might be able to simplify this a bit. My primary focus here is making sure I get to ask questions of the general manager. And if Mr. Becerra is willing to make a representation to the hearing officer that he will be testifying as part of their case in chief, then I'm happy to wait on my cross-examination. If that's not entirely clear, then I'm going to serve him with a subpoena so that I am certain to get a chance to question him. So that maybe that simplifies things.
Mr. Becerra, go ahead.
So two things. First, yes, at this point, we plan to call Mr. Ashlock as a witness. And so we'll be submitting written testimony. What concerns me, however, is I have no idea what it is Mr. O'Brien wants to subpoena him to testify about. And so to the extent that it's beyond what we plan to have him testify about, once again, it's unfair surprise within the context of the state board's procedures if he's able to do that as effectively case in chief evidence simply on cross-examination. We would request that Kern Water Bank Authority be required to make a written offer of proof as to what testimony they're seeking from Mr. Ashlock as part of their case in chief.
Maybe I wasn't clear, and I apologize for that. What I was suggesting is if Mr. Becerra is going to call Mr. Ashlock as part of his case in chief, I will wait until my opportunity to cross-examine him to ask my questions of Mr. Ashlock. So I would basically be in the same position as every other cross-examiner in this proceeding. I would be able to ask whatever questions I wanted to ask, even if they were beyond the scope of his direct. Those are the rules that we follow. I think asking me to submit an offer of proof in advance as to what my cross-examination will follow puts me at a disadvantage. And I don't think, given my offer to not call Mr. Ashlock as part of my case in chief, I don't think that would be appropriate.
Thank you to both of you. I think, there's two issues. There's the state water board practice, which has been that cross-examination outside the scope of the written testimony is allowed. On the other hand, as Mr. Becerra, as you pointed out, it does allow other parties the opportunity to ask unanticipated questions that are not within what would normally in a trial setting be considered cross-examination, because there in that situation you would be limited to the direct testimony. Let's pause on this. I I want to turn to that. You raised the other issue of the State Water Board witnesses, because I think there's some similarities. They're a little bit different. Mr. Jacobs, I believe it's your client who had identified the two State Water Board witnesses. I wanted to talk to you about that. I think in that case, it's very likely that I will ask you to have some kind of, if you will, offer of proof or identification of the subject matter of that testimony, which is why I'm thinking about the two in context with one another, because I wanted, there are differences in these situations, but I'd like to treat them somewhat similarly to the extent they're consistent. But maybe Mr. Jacobs, can you comment on the likelihood, I guess, that you anticipate calling State Water Board witnesses? And then we will have to have a conversation about the process for this. The reason is that these are witnesses who are staff of the division. We had a situation in our situation in a different AHO hearing in which State Water Board witnesses were called. Those were members of the enforcement staff. So it's a slightly different procedural posture. I think here you have having division witnesses. In theory, these are individuals who are on the advisory side of things at the State Water Board. That doesn't mean that they may not have relevant information that might be appropriate for this hearing. So I don't mean to suggest that I think that. I just think there's certain sensitivities that we need to be aware of, and this is a little bit new territory. So maybe you can comment on what the likelihood that you'll call these witnesses, and I mean, you identified them, so I suspect you plan to call them, and whether you have any suggestions on how to approach that.
Sure. And I appreciate the sensitivity and the intent behind calling these witnesses is simply to be able to introduce and explain the joint water availability analysis and the process that went into that. I think it's super relevant.
So let me pause right there. These are, to your knowledge, and I actually don't know, but to your knowledge, these are staff who were involved with the solicitation of the joint water availability analysis or conversations related to that joint water availability analysis.
That's correct. Mr. McCarthy signed the October 2018 letter that includes the methodology. And I believe Mr. Moody was involved in the meetings and involved with all of it. Now, I am not sure that Mr. Moody still works at the Water Board. We got to bounce back on his email. But we will run that down, and I don't want to, if his testimony is not necessary and he's not currently working for the board, maybe we won't call him as a witness. But again, the intent is to provide you with as much information as you can have on the process that went on before you were involved.
And that makes some sense to me. I just, as a matter of practice and thinking about how this moves forward, I do think you mentioned that you've got to bounce back on the email. To the extent that these staff, at least for right now, are within the advisory team, and we may need to, I'm not sure, think about how this works. We do need to be careful about communications. And those should be CC'd, all parties should be CC'd on any communications. And I think probably State Board outside of my office will need to figure out an appropriate point of contact as we move forward if these are to be identified as witnesses. So we're in new territory here. I think we're all trying to understand how this might work, and we haven't worked that out. But I just wanted to flag that as a potential issue, that any communication with division staff should include the service list.
Okay, so I thank you for clarifying that. That was not my understanding from what is the ex parte explanation that's been in the current notices.
And it may be brief, and it may need to be revised. As I said, we're working on this, but the division staff at this point, because this is not an enforcement proceeding, although I'm not including enforcement staff, and these are not enforcement staff, these would at least initially be presumed to be part of the advisory side of our proceeding, unless we identify otherwise, because there may be certain reasons. So
okay,
we may need to
if I'm not able to, well, it was my intent to try and have a discussion with Mr. McCarthy and explain to him the limited scope of what I intend to ask.
Mm-hmm.
And I don't know if he will have that discussion or not. what I'm trying to say is I may then move forward with the deposition subpoena and go that route. And
Right.
of course, everybody here would get that and could participate.
Right, and without addressing kind of the how do I say that? Without getting to the merits of the deposition subpoena, that may make sense because I don't think there is a way at this point for you to have a conversation that would be appropriate without all other parties there and present,
Okay.
given the posture. And just as a larger issue, in this case, it may not be of significance, but there is some concern, of course, from the AHO that parties not be able to thin out our advisory technical support team by calling them as witnesses. You know, there's some concern with it. We need to maintain some ability to access that technical reserve that we may need to help support our decision making. All that being said, at the same side, being perfectly transparent about who it is that the AHO is talking to and having discussions with and who is on the hearing team. So I recognize that there's a complicated issue here, and we will try to work through this in a way that is fair for everyone and that is transparent. But it's not immediately obvious today how this should go. I just wanted to flag it and talk to you about the intent. I'm going to think about it. Maybe we, I don't know, what do you think, Mr. Jacobs? Do we need to reconvene on this issue with a pre-hearing conference? What I'm thinking is that the State Water Board, the Office of Chief Counsel may need to be involved in this. This is not my role to represent staff in any way. And so I'm wondering if there needs to be another pre-hearing conference where we invite an appropriate representative from the Office of Chief Counsel to talk about, to participate on behalf of staff and how we move forward with this process. Does that make some sense to you?
That's your call. I will probably get out the deadline notice sooner than later so that we're not jammed up.
Right.
But let us know what you want to do on the pre-hearing conference.
That's what I'm thinking now, is that maybe we have another pre-hearing conference well before April 4th, that we can clarify some of these issues on the witnesses. And I'm going to move back to Mr. Ashlock. But let's schedule something so we can meet specific, at least including the specific issue of the State Water Board staff. I'm turning to my calendar. Maybe I can ask you, Mr. Jacobs, do you have an estimate of when you plan to get out a deposition notice? It may make sense for us to have that conversation after the notice is out, and then there's a concrete.
We can do it tomorrow.
Document. Great. Not that I'm necessarily encouraging, but
they're already drafted.
Okay.
Gotta take one last look. Yeah.
Ms. Kinsey, if I could make a suggestion, it might be helpful to ask council to meet and confer on these issues. I suspect that we could probably reach agreement on things like the deposition, perhaps even the Mr. Ashlock issue. This group of council have worked together for many years. I suspect we can probably cut through some of the details of this. I certainly wouldn't object to a deposition of Mr. Jacobs' witnesses. That would give all of us a chance to ask questions in advance of the hearing.
That is a good suggestion. Thank you, Mr. O'Brien. What I plan to do now is put a pre-hearing conference on the calendar and I will ask the parties to meet and confer on these issues. And then to the extent that there are any issues that remain unresolved, we will hold that pre-hearing conference and address them. To the extent the issues are happily resolved, we can always take that conference off calendar. So I think that would make sense as a way to move forward. I'm just trying to, maybe I'll turn to you, Mr. O'Brien, and then Mr. Jacobs and Mr. Becerra. How much time would you like to meet and confer before we reconvene? Do you have a suggestion?
I think relative to Mr. Ashlock, it's pretty brief. Actually, I was going to make a suggestion that perhaps short circuits that. I think I assume that when we submit our cases in chief, we will be able to, we'll all be, at least have the ability to submit an amended notice of intent, which might include other witnesses or fewer witnesses. I guess what I would suggest is if Kern Water Bank Authority does not designate Mr. Ashlock as a witness, then there's no issue here. Ultimately, they can cross-examine him. We plan to present him. He'll be subject to cross-examination. If that's sufficient and Kern Water Bank Authority does not include him as a witness on their amended NOI, I think we're kind of done with this. If they do include him as a witness on the amended NOI, then I request an offer of proof along with that. So if all they want to do is cross-examine, then of course they get to cross-examine.
It sounds to me like we're moving in the right direction. That sounds pretty close to resolution already. But I'm going to leave it as is and make sure you hammer out the details and have a mutual understanding. It doesn't resolve the State Water Board staff issue, which I realize is a little bit more, it's difficult because to some extent there needs to be a conversation possibly between probably a member of the Office of Chief Counsel and Mr. Jacobs about how to handle this. So I think what I'd like to do is put a few weeks out, a hearing conference on the calendar. I'm looking at February 22nd. That would be approximately or exactly 3 weeks out.
Jury duty that morning.
Oh boy. Well, then not that date. And you probably don't know how long that extends. Is that accurate?
Not yet, no.
Okay, let's look at the next week then. Looks like we could do the morning of March 1st. Would that work for you, Mr. Jacobs?
Yes.
Are there any other obstacles for those of you? I realize not all of you may need to be involved in this particular pre-hearing conference, but it is up to you. Are there any scheduling obstacles to that? All right, I'm going to set an additional pre-hearing conference on March 1st. I will identify it as to address any remaining issues that can be anticipated at that time related to witnesses identified on the NOI. However, if there are other issues that come up that you would like to raise, other procedural issues that you would like to raise at that pre-hearing conference, I think we can address them at that time. So I'm not going to necessarily limit the scope, but primarily for the purpose of checking in. Hopefully that will give Mr. Jacobs you enough time to make some movement perhaps on alerting the State Water Board through an appropriately served document of your intent to call these witnesses and for movement to occur outside of the bounds of this office, depending on what needs to happen with the Office of Chief Counsel and representation of those witnesses. And then to the extent that anything remains to be resolved, we can meet on March 1st and address them.
Sounds good.
Great.
Hearing Officer Kunze, can I suggest a couple of things? And I think maybe you're going to get to them, but I want to make sure we don't lose track.
Yep.
We've now begun to frame the scheduling for the case in chief with exhibits and such.
Mm-hmm.
But 2 points is one, don't we need, because I think it will serve as a filter to what those exhibits would be, is don't we need in advance of that the legal briefing on the scope issue? Because depending upon how you evaluate and rule on that, that very well may drive what exhibits would be appropriate to be submitted on the 4th. That's
Please,
one
Mr.
question I have.
Sure. Well, let's start with that because maybe we didn't have a meeting of the minds, which is I don't want to address those issues without having seen the evidence.
Okay, you want to do it in the other fashion. Okay, so
right,
okay,
and it may be that we don't explicitly. I actually at this point, I'd like to see what is said, but I at this point don't explicitly intend on ruling on anything until and proceeding towards the hearing unless there is something.
Fair enough, and I'm tracking with you now. So let me go to my second issue that I think you just maybe have not gotten to it. Is we now have the schedule for the written objections, but I think we also need, it was really facilitating in phase 1A. There needs to be a schedule of written responses in advance as well.
Yes,
And maybe we just didn't get there yet.
we just haven't
maybe
gotten there
it's-
yet. So yes, thank you. I think I was sidetracked by witnesses.
Okay.
I'm writing down our schedule so far. So I think we have written objections and then some period of time after that, an opportunity to respond in writing to those written objections. What had been, we have time. So I'm looking at what was proposed in the pre-hearing conference statements submitted to me, but those timelines were a little bit more condensed than what we now have in front of us, which is nice. We have a little more breathing room. I would think a week would be appropriate for responses, which would put us, I believe, at April 25th.
Yeah. I included the same. That would be probably sufficient.
Are there any concerns or objections to April 25th as the deadline for submitting written responses to written evidentiary objections? Good, and then that gives us some amount of time before the hearing for me to digest those, so that is helpful. We haven't gotten to rebuttal yet, but we're going to do that. But let me just reiterate, we have a pre-hearing conference March 1st. April 4th is the submittal of case in chief evidence. April 18th, the deadline for written objections. April 25th, responses to those objections. And I'm going to memorialize all of these in an order. I just am repeating them here for our understanding. And then May 2nd through 6th and 9th and 10th, we're holding for the case in chief hearing. We also need a deadline for pre-hearing briefs. I would propose doing that the same date as the responses to objections, so that would be April 25th. Are there any, and then the proposal was 15 pages. Are there any comments on either that deadline of April 25th or the length of those briefs?
Ms. Kinsey, I don't have any objection to the date. I am concerned about the page limit at this point. It's really difficult to know what exactly we'll have to brief until we see the exhibits. So if we're talking about evidence that goes back to the 1860s, that's a lot different than if we're talking about things following decision 1196.
Yes, so noted. What we'll do is I will set the deadline and a tentative page limit of 15 pages. And then we are also going to have a pre-hearing conference because I enjoy meeting with all of you. Let's have a pre-hearing conference, I think after the case in chief submittal. And then at that point, that would be the time to say, hey, look, there's so much to say. I really need more than 15 pages. Does that seem appropriate? So that what that would do is sometime between April 4th and April 25th, we would want to have a pre-hearing conference, another one. So let's turn to our calendars. I realize Mr. Pierce will not be with us for one of those weeks, so we're somewhat limited. And I'm out the following week. Let's see. April 18th is would be the day for it. Does that make sense? I mean, does that, I'm trying to recall the reasons for having that would be to discuss whether there are any significant changes to the schedule, also any anticipated or any other issues that we just haven't addressed today that may have come up after the submittal of the case in chief evidence on April 4th. Does anyone have any comments about a pre-hearing conference on April 18th, either that it's absolutely necessary or unnecessary, or my inclination is to schedule it, and then if we don't need it, we can always take it off calendar.
I think that's wise, is to have it scheduled, and then maybe we'll have good cause to say it's not necessary, but I think it's getting it on our calendar will be facilitating.
Thank you, Mr. Cooney. Mr. Becerra.
Ms. Kinsey, I agree with Mr. Cooney on that, but I do have one suggestion. I'd suggest, if it's possible, April 20th, possibly 21st. The way we set the schedule up, we will be submitting all of our written objections on the 18th. I suggest it may be productive for you to see them before you talk to us about what comes next.
Yes, it would be. The obstacle I'm dealing with is we do have a tentative hold on our calendar, although I could beg for some time from the other hearing officer for some time on the 21st, or maybe they won't need it. So let's look at the 21st. It could be subject to change if I'm just not able to get time on our calendar, but let's aim at the 21st. Are there any obvious conflicts that any of you have, either in the morning or the afternoon? We may have to do an afternoon depending on what works best for the other hearing officer on the other matter. Great. Okay. Tentatively April 21st. That makes a lot of sense, Mr. Becerra, because it would help me to look at what comes in on the 18th. All right, I think with that, we're ready to talk about rebuttal. One step at a time.
Can I bring up, I'm not sure where it fits in your outline here.
I'm not sure either, I'm sure. So at this point, so please, yes, Mr. Cooney, go ahead.
2 points as they relate to phase 1A. One was the subject of evidentiary record, and we had suggested a protocol that if a party wanted to bring forth an exhibit from A into B, that would be fine, provided that if it would need to be affirmatively shown to be relevant, and it could be subject to an objection to which you would rule and say it is or it isn't. I would like to know whether that's an acceptable process. And then the second 1A issue was that, again, for not only for the reason of concluding your process in deciding the answer to issue 1A, that you make a written ruling. And I think it's also important to help clarify what the nature and scope could be into 1B, because they run into each other. Even by definition, it's been defined as, that which is in addition to. So we would request that written ruling be provided, after you've received all your briefing, which you haven't yet done. I don't know where that fits in this matrix, but I'd like to bring those two issues up.
Thank you. Those issues are on my list. Let's schedule, and I appreciate it was good of you to bring them up again. Let's go ahead and let's work on this rebuttal issue, and then we'll turn back to this. And hopefully we won't go on. We're getting there. We'll go on too long, but let's work on the scheduling and get that hammered out to the extent we can. So currently we have April 4th as the case in chief submittal. That means, and then the hearing is May 2nd through 6th, the 9th and 10th. If the deadline for submitting rebuttal evidence is after the hearing, that will, in its own doing, provide at least a month, in excess of a month between the case in chief submittal deadline and then any rebuttal submittal deadline. So I don't think that is a concern. But I think based on scheduling conflicts, we were looking, the earliest we could schedule the rebuttal portion is the week of May 6th. I'm sorry, June 6th. Because
Ms. Kinsey,
otherwise,
I'm sorry to bring this up since I had the prior scheduling issue, but the first 2 weeks in June are not great for me.
okay. Not particularly great for me either, but I was contemplating. So by first 2 weeks, you mean, so that would put us out to June 13th, the week of June 13th?
Actually, I believe actually part of that week is not good either. Yeah. starting the week of the June 20th is open for me.
All right. And excuse me, I'm looking at my calendar and thinking. Here's what I want to do, and I need to take a look at a couple of things because I didn't have my calendar necessarily sketched out. And I realize you all may have to talk to witnesses and there are other potential issues, but I didn't have my calendar sketched out quite that far. Can we take it? Well, I'm not going to let's take a 4-minute break. We can all look at our calendars. And then let's come back into the room at 11:38 and hopefully we can set this up. So just 4 minutes and we'll come back to it. Thank you. All right, I'm back online. I'll just give us a second for everyone to get their cameras back on, if you would like. So I'm looking at a proposal that we do look at for rebuttal, the rebuttal portion of the hearing. I'm looking at June 28th, 29th, 30th, and July 1st. Are there any known scheduling conflicts with those 4 days at this point?
This is Jennifer Spalletta for Rosedale, and I have a pre-planned vacation during that time period.
Okay, so we may have, is that true the week before?
Just look here. It will start probably on the 27th of June. So the week before
Okay,
the 20th is okay for me.
okay. So let's look then at June 20th through 24th. Are there known conflicts on that week?
Ms. Kinsey, we do have one witness who is out of the country from June 1st to July 15th.
15th, yes.
Suppose we could bring him back for a few hours after the 15th of July.
We could do that, or we could find a short period of time somewhere between May 10th and June 1st, possibly. That's another possibility.
The question at this point is, I just don't even know if he'll be necessary for rebuttal, so.
Exactly. So let's, I think, as I said before, we won't play it by ear, but it's an issue maybe we won't address today. But understanding that we may need to address it, whether it is to come back at some later time if necessary, or schedule another date,
Well, and
portion of a day.
if I might suggest, I mean, we'll know by the April 21st pre-hearing conference at that point. So
Okay,
perhaps it's the case we might be able to accelerate whatever it is he needs to get done, if anything.
great. So let's address, well, let's see how much we know at the April 21st conference, and we'll address it then. Thank you. And remind me, because I may forget. So now we're looking at June 20th through 24th. That's 5 days. It's rebuttal. Hopefully we can get it done sooner, but I don't want to cut us short, especially since we're having so much difficulty scheduling days. So are there other known conflicts for June 20th through 24th? All right, I think we have a rebuttal portion of the hearing, which means we need to set a date for the submittal of rebuttal evidence. We could do it approximately a month in advance, since we have the time, and do it around May 20th. Let's see. May 20th is a Friday. There may be some, maybe the May 23rd, give you the weekend. That seems to be a common request. Are there any concerns or other thoughts about setting May 23rd as the deadline for submission of rebuttal evidence? And does it make sense to all of you to set similar deadlines for written objections to that evidence? Yes, I see head nods. Okay, so let's do that. We can do it 2 weeks after, just as we did with the case in chief. So that would put us at June 6th. And then a week later, June 13th, for responses to those objections. I believe we now have deadlines for all of the things on my list, which is not to say there aren't other things to talk about, but are there any other hearing related deadlines or scheduling that you can think of that we should discuss at this time? Thank you. Good for us. All right, Mr. Cooney, I think you had some appropriate questions about how to handle the record for phase 1A, and then I think a general conversation about when we might expect some kind of outcome from phase 1A. On the first issue, I think the two are related, so let's talk about them together. One of the things is that if any order that's presented to the board on phase 1A and phase 1B are presented together, which I think they probably should be, seems a little odd to me that the record for the two proceedings, I mean, by nature, phase 1A will not include the phase 1B hearing matter, so that's true, but that the record will be different. I don't know that that's necessarily a problem. We can probably delineate it. So I guess my question is, what I was trying to think is, should the default be that the phase 1A record is going to be in the evidentiary record absent objection, and then give everyone the opportunity to make an objection to specific items? Or is the default the reverse, where it's out unless parties propose to move in specific documents or portions of testimony or portions of the record into the record for phase 1B, and then there would be a corresponding opportunity for objections? So maybe Mr. Cooney, you can go first on whether you have a recommendation one way or the other, whether the default is in or out, and which makes the most sense to you, and then I'll hear from the other parties if there are other opinions.
I think it should be treated like any other evidence that a proponent is suggesting is relevant to 1B. So if somebody believes that there's something in 1A, an exhibit that is in the city's exhibit list or North Kern's exhibit list, it was admitted by you after your legal rulings, then they should add that to their list, and it would come in absent somebody being able to say, because you have stated the issue differently. 1A is obviously a different issue than 1B, and you've also prefaced that no evidence comes in to either phase unless it's relevant to the issue. So it needs to be evaluated whether or not there's, for some reason, a given exhibit that is being proposed that is just really not relevant to the issue. And I leave that to you. You'd be able to figure that out. I don't think it's correct that we could say as a matter of fact that we believe all evidence in the evidentiary record of A is relevant to B. I don't think that is a correct proposition given the nature of the issues. And I don't think it's much of a burden for anybody to say, I think exhibit X ought to come in, and then somebody would file a written objection if for some reason they didn't think it was relevant. I think they just stand on their own. They're either in or out if it's relevant.
Thank you, Mr. Cooney. Are there any concerns with requiring the parties to submit any portion of the phase 1A evidentiary record by the April 4th case in chief submittal, to the extent it's case in chief? I realize maybe it could come up as an issue that's related to rebuttal, and then you'd submit it by the rebuttal deadline, but by the appropriate evidentiary deadlines. Is there any concern about addressing the phase 1A record in that manner? Mr. Becerra, I'll look to you because you unmuted. I also see Mr. Pierce, you're on my list.
I only have one comment, which is I think what Mr. Cooney's proposing makes good sense. I would just request, though, that if we go that route, that you need to offer phase 1A evidence anew in phase 1B, that we can do it by cross-reference to the exhibit number in phase 1A. The thought being that if you don't do it that way, all of us may end up submitting 5 copies of things that were already submitted in phase 1A.
Yeah, and I didn't deal with that mechanic, and I think that's exactly right. If I don't know, I'm going to pick one. The Miller-Hagan agreement is in phase 1A. If somebody wants that, then it comes in under the number North Kern, whatever it was, I don't recall off the top of my head. Absent, for some reason, somebody believing that they need a different version for whatever the reason be. But absent that, it'll create chaos if we all of a sudden start switching numbers on things that you've already made a determination that have come in appropriately into the record.
Thank you, Mr. Cooney and Mr. Becerra. That makes sense to me. It also raises another mechanical issue, which I think I hadn't thought of and is important. It seems to me for phase 1B and then probably for phase 2, we should continue our exhibit numbering in sequence so that we don't reuse any of the same numbers with respect to the same party, so that we don't have two ways of referencing. Well, we don't have one reference to two different documents. So let's keep that in mind. I will try to memorialize that in the order that comes out of this pre-hearing conference.
I had thought of that too, and I think you're exactly right. It just needs to be sequential.
Good. Mr. Pierce.
Yes, thank you, Ms. Kunze. And I don't know if I don't know if I disagree with Mr. Cooney or Mr. Becerra. I think we're all going to say essentially the same thing, but my thought is more practical. The evidence that came in during phase 1A, you admitted that into evidence. There were objections to some of the evidence. You heard those objections. Some of the evidence stayed out. A lot of it is in. I don't want to have to resubmit any of that. And my position would be, if it's in evidence, it's in evidence. But I also understand that some of the evidence in phase 1A may not be relevant to phase 1B. And I also understand that some of the parties who are going to be more active in phase 1B were not active in phase 1A. So I guess I would suggest something along the lines of, it's the evidence that is in evidence for phase 1A is considered in evidence subject to relevancy. And although I would think that somebody could object on basis of relevance if they have a problem with the evidence, but otherwise it's in evidence. I don't want to have to resubmit it again and argue relevance related to phase 1A if I can avoid that.
Well, let's try to drill down a little bit about the practical issues here. When I say resubmit, what would be due on April 4th or the rebuttal deadline would be an identification of those exhibits, because they're already available to the parties. You would not need to resubmit any copies of it. I wouldn't ask for you to resubmit hard copies to the AHO, but it would be a list, a spreadsheet identifying which of the exhibits you seek to explicitly include, and from phase 1A that you seek to explicitly include in the phase 1B evidentiary record. And I think when I asked about should the default be in or out, I think Mr. Cooney's argument, if I understand, was, well, it's not much of a burden on the parties to simply identify those exhibits. And I want to hear from you whether you perceive that there would be such a burden and what that would be.
No, I don't see a burden in identifying them. I guess I was thinking more along the lines of the default should be it's in evidence subject to an objection based on relevance. But yeah, I don't have a problem identifying evidence that we think is relevant for phase 1B.
Okay.
One finer point, if I can, I mentioned, and it was in our statement, and that is the evidentiary record of 1A has closed, and all evidence was submitted, and the 1A evidence is concluded. And matter of fact, we're all in the midst of briefing that, to which you're going to then make your ruling. I want to make sure it's very clear that if somebody decides appropriately that they wish to reference an exhibit from 1A into 1B to bring it in because they believe it to be relevant to 1B, and you concur, that does not reopen the evidentiary record to which you need to decide the issue 1A. I mean, that's why we have phases, and that's why we had, NOIs, and that's why we had evidentiary objections and argument and such. I want to make certain that we're not reopening the evidentiary record of 1A, recognizing that ultimately there is a record that goes to the state board. I appreciate that's a different animal. But the evidentiary record to which 1A is going to be adjudged is based on the law and the facts that were submitted in 1A, not what's going to show up in May or June or July, whatever it is in 1B. That's a very important principle.
Yes, Mr. Cooney, and that is my understanding. I mean, which means that any testimony or evidence that comes in at this point would not be considered and relevant to my determination or my recommended proposed order in phase 1A, which is important, I understand, because there would be no need to cross-examine, and it wouldn't be allowed. I would not allow you to cross-examine these witnesses with respect to phase 1A issues because that evidentiary record is closed. Not putting aside, I don't mean to suggest anything, and hopefully this absolutely would not be necessary, but understanding that, of course, parties would have the opportunity to make some kind of motion to reopen the record. I'm not sure what any ruling would be, but that there would be a process for doing such a thing, and that would be a process in and of itself. So that is my understanding of how this would proceed. I think, so what I'm going to do based on this, I think I will take the approach that the parties are required to identify those portions of the Phase 1A record, whether they are exhibits or testimony, portions of the hearing testimony, that they seek to have included in the evidentiary record for Phase 1B by the deadlines for submitting evidence, whether it's case in chief or rebuttal, and then those would be subject to objections just like any other evidence, and we would deal with those in terms of relevancy and such, just like any other evidence. Now, I realize testimony gets tricky, and I don't know if we need to deal with it now. Testimony gets tricky because there was not an opportunity to cross-examine the witnesses in Phase 1A with respect to Phase 1B issues, but let's deal with those if and when that issue comes up. Now, I think, Mr. Cooney, there's a second portion to your to the issue that you raised, which is a ruling on the Phase 1A issues. Any ruling at this point would be, and now there's time, and based on the scheduling, there is some time for me to attempt to get out a ruling before we get to the Phase 1B hearing. Any ruling from me would be an interim ruling of some kind. It would not be something that, it is not a proposed order that would be going to the board. It would be, and to some extent, I don't know, it would be subject to, I don't want to say amendment, but it would not be, it's not something that is final from the AHO, and it's not something that would be final as adopted by the State Water Board. But it would provide you with information about what my assessment of the evidence from Phase 1A is, where I am going on the issues. I can see it may be relevant. So my question is going to be, is that helpful to you, given that any ruling for me would not be binding on the State Water Board and their final decision, but it may help guide you in the Phase 1B process. So I'll look to you first, Mr. Cooney, and I realize others may have thoughts on this as to whether such a ruling would be helpful to you in preparing for Phase 1B.
Short answer to that, would it be helpful? Absolutely. I think it is also appropriate for, just as your prior orders have suggested, is that the law and the facts need to converge into a written ruling articulating and answering directly the question of Phase 1A as to whether or not the forfeiture decision resulted in unappropriated water, and if so, in what amounts that you would articulate. Recognizing that that is a written ruling, just like your evidentiary rulings, just like all of your rulings that are still part of a bigger process. And we understand then there's going to be a 1B, and there's going to be ultimately at some stage a proposed recommendation and maybe a proposed order in whatever manner you produce, that is then, of course, going to the State Board for its consideration. But it nonetheless is very important to provide a direct and clear answer to a fundamental issue that has been unresolved since the 2010 hearing. And so that's very important in its own respect. And then I think it is very directly edifying in terms of the scope of the 1B issue, because as it's even defined in your definition of 1B, it is that which is 1B is additive to whatever, if anything, there was in 1A. So they talk to each other. And so I think getting that resolved to the extent of your abilities, I think is very important and edifying to all of the parties as to what has happened in this process. Because the 1B evidence isn't answering the 1A issue. So that's our position. And I think it's very important that this get done. We've been a long time coming. And, of course, this is very much the same of what I suggested at the end of the hearing on the 9th of December, the 10th. I can't remember the date, the 10th. So our position is consistent, and we think it's very foundational to the orderly administration of this proceeding.
Thank you, Mr. Cooney. Mr. Pierce, I see you are also off mute. Would you like to comment on this?
Yes, thank you, Ms. Kunze. Yeah, I believe I made this point earlier a couple times today, which is it's our position that you should not issue a decision on the Phase 1A issues until you've had a separate hearing on the public trust issues. And we believe that's necessary and required. We believe you're required to consider public trust in the course of making a water allocation decision. I do appreciate and I do agree with you that if you did issue a ruling, however, it would only be a preliminary non-binding ruling. And I think we clarified that very well with the board through our petition for reconsideration. But I guess I don't see the real value in giving an interim decision until you've heard all the evidence from all the phases, and really, in particular, until you've heard evidence and testimony on public trust issues. So I guess we would disagree with North Kern, and I don't see any real. Not only do I not see a need, I don't think it would necessarily change in any way how we approach Phase 1B. I think that is a separate issue. I don't think Phase 1B is dependent on what happens in Phase 1A. And I will actually, I just will point out that we, I mean, in some ways, I think this is almost a substantive issue. And in fact, we've addressed this issue somewhat in the legal brief, which we filed just a few minutes ago, our opening closing brief on the Phase 1A. So you'll see some authority and argument in there on this issue as well. Thank you.
Thank you. Good. Are there any other comments on this issue? Mr. O'Brien?
This is on a different issue, Ms. Kinsey. I have a conflicting commitment starting here at noon. I can be a little bit late for that, but I apologize for having to bring this up. But so I know we've scheduled a follow-up conference. I think there's some issues like order of parties and that sort of thing. I think we could probably defer to the next pre-hearing conference. So I just wanted to let you know about that constraint.
Thank you, Mr. O'Brien. I appreciate that. I don't think any of us anticipated it. I knew it would be long, but 3 hours was, longer than any of us probably blocked off for this. So thank you for that. I think at this point, I'm going to defer on this question of the Phase 1A ruling because Mr. Pierce appropriately pointed out there may be some issues on this that the parties have actually briefed. So I'm going to turn to those, but keeping in mind the comments that you've made today about the helpfulness of that, of having such a ruling or not.
If I can just want to go to the last point that Mr. Pierce raised. If in fact you determined that the decision did not result in any unappropriated water, then that's the answer to the Phase 1 issue. And it doesn't reopen in Phase B or C or 2 or 4. That's the answer to the question. And there would be no further proceeding with regard to the forfeiture decision. I think that's what the law provides.
Thank you, Mr. Cooney. So I think the final issues on my that I have listed here, we can divert. We have a March 1st pre-hearing conference potentially on the schedule, but issues like hand delivery of documents, which in the shorthand, yes, it certainly is an option if you would like. Technical memoranda from experts, I have that on my list. Margins on pleading paper, which I understand there's some lack of clarity because I haven't used pleading paper in a really long time. Some minor issues like this, I will try to address those to the extent I can and clarify those in an order coming out of this conference. To the extent you have concerns about the way I address them, or if I fail to address them appropriately, let's revisit them on March 1st, and we can go from there. Mr. Jacobs, yes.
One last issue,
Yes.
Ms. Kinsey, can you clarify, you don't have to do it right here on the call, but perhaps in your next order, who is on the advisory team we're not supposed to contact? I want to make sure we're following those rules.
Yes, no, thank you. And I realized there probably that portion of the hearing notice needs to be revisited and clarified. So yes, thank you. I will look to that. Are there any other issues that need to be addressed today before we break, reconvening on March 1st to address anything remaining? Well, I want to really thank all of you for your hours this morning with me. This was very helpful. I think we accomplished quite a bit in moving this forward. We're on track. We have at least a plan, and I appreciate your working together. I will memorialize our discussion in a post-hearing conference order. If you have any concerns or think I have failed to address anything important or failed to properly memorialize what you understood to be what we talked about today, you can feel free to respond to those. We'll also meet again on March 1st, which will be another opportunity to discuss those issues. So thank you very much. I really appreciate all of your time, and we are adjourned for now. Thank you.
Thank you.
Yeah, thank you very much.